This is Bloomberg Law with June Grasso from Bloomberg Radio.
Today, an indictment was unsealed, charging Donald J. Trump with conspiring to defraud the United States, conspiring to disenfranchise voters, and conspiring and attempting to obstruct an official proceeding. The indictment was issued by a grand jury of citizens here in the District of Columbia, and it sets forth the crimes charged in detail.
Remember about a year ago when special counsel Jack Smith announced the criminal charges against former President Donald Trump, accusing him of plotting to overturn the 2020 election? That case has been frozen for almost 8 months as Trump's claims of presidential immunity went all the way up to the Supreme Court. But on Tuesday, the special counsel basically announced it's game on by filing a superseding indictment with the exact same 4 charges, but recalibrated to fit the Supreme Court's controversial decision giving presidents sweeping protections against criminal prosecution. That followed Smith's action on Monday, urging the 11th Circuit Court of Appeals to reinstate the classified documents case against Trump, a case that was thrown out entirely last month by Judge Eileen Cannon in a stunning, unprecedented decision. Joining me is Dave Ehrenberg, Palm Beach County State Attorney. What do you make of the special counsel filing to restart basically both cases this week, Monday and Tuesday, 1-2 punch?
Jack Smith had to do what he had to do because the Supreme Court pushed him into this situation, and Judge Cannon in South Florida pushed him into this situation. So he's just reacting to outside forces. This wasn't something that he wanted to do before the election to try to make it an election issue. He was just being a lawyer, following the evidence in the law and doing what the law required. And so I'm glad he did this because I've always thought that, at least in the D.C. election interference case, that the Supreme Court's immunity ruling really does not gut the case at all. I mean, you got to shave around the edges, but other than that, the heart of the case still remains.
So you weren't surprised that the 4 charges are the same?
No, I would be surprised if it weren't the same because the only part of the D.C. election interference case that needed to be excised was any reference to Trump's alleged influence on the Department of Justice to try to pressure the states to redo the election, to accuse the election of being fraudulent, to threaten to remove the acting attorney general unless he did Trump's bidding. That stuff, according to the Supreme Court's immunity decision, is all covered by presidential immunity because it's within his core duties to name an attorney general, to have an executive branch that works with and for him. So he's able to get away with that.
Chief Justice John Roberts, in the immunity decision, wrote that a president is at least presumptively immune from prosecution for his interactions with his vice president about constitutional duties, including the vice president's conduct in overseeing the Senate. Is that going to be the most perhaps problematic part of the superseding indictment in that it keeps in evidence about Trump trying to pressure Pence into disrupting the electoral count?
I don't think so, June, because all of that can be overcome. It's a presumption of immunity. You just have to show that by prosecuting the president, it does not impinge upon the powers, the official acts of a president. You don't want to diminish the powers of a president by going after a president for talking to his vice president. And the reason why it does not impinge upon the core powers of a president is because he was not talking to Vice President Pence as a member of his team from a White House perspective. It was as a candidate for office. He was talking to Pence to help fix the election. He was talking to Pence as an office seeker, not an office holder. And also, in any event, Pence was acting as the president of the Senate, not as vice president per se. And so that's another way you get around it, was that this does not hurt the powers of a president to say you're going to be held responsible for your improper communications with Mike Pence as the president of the Senate. Now, if you were talking to Mike Pence about foreign policy in his role as vice president, yes, that would be protected. But not when it comes to Trump trying to overturn an election, which is not an official act, as a candidate for president, not as the president, as a candidate, and in so doing, going after Mike Pence as the president of the Senate, not as vice president.
The Supreme Court's opinion basically changing what people thought the law was, and yet there's very little guidance in that opinion for prosecutors going forward.
Yeah. The Supreme Court decision is broad and it is confusing. And Jack Smith went up and down the chain at DOJ talking to the Solicitor General and others to come up with wording that they thought could pass muster. I do think at some point, maybe when there's change in the Supreme Court, that this decision will be reversed, just like others in the dustbin of history have been reversed, like Plessy versus Ferguson, Korematsu. There are a litany of bad decisions that have been reversed over the years, and I think this will be one of them, because they took something that doesn't exist, presidential immunity. I mean, before this opinion, presidential immunity existed in the civil context, but not in the criminal context. And the way they broadened it gave the executive branch unprecedented powers that never existed before, and it has set forth all this confusion that not only can you not prosecute a president for his official duties, and they've defined that very broadly, but you can't even get evidence of unofficial acts, criminal unofficial acts, by way of his official duties, meaning that you can't go and interview Department of Justice officials to find out that the president may have sold pardons for bribes, right? So the way they've done it is not just hurt prosecutors when they can't prosecute a president for official acts, but they have kneecapped prosecutors in their investigations.
Let's talk about what happens next. There's a hearing before Judge Chutkan next week. Do you anticipate the defense objecting to the superseding indictment, and then we'll have more motions, more hearings, more appeals?
Delay is their middle name. They're going to keep pursuing delays. They're going to say that this superseding indictment was meant to influence the election and it should be delayed. This is election interference, which is ironic because Trump is being accused of election interference. And they'll find creative ways to say that the indictment still violates the Supreme Court's mandates in the immunity decision. And then once they get a negative ruling from Judge Chutkan, they're going to appeal it. And, they just want to forestall this as much as possible. Ideally for them, they want this trial to take place half past never. And they'll get what they want if Trump gets elected. Trump will just tell his new attorney general to dismiss everything. But if Trump loses in November, then this will be the first trial that he faces after the election.
The Supreme Court directed Judge Chutkan to determine which allegations in the indictment involved official acts by Trump. Do you think she can decide whether this superseding indictment comports with the Supreme Court's decision without calling any witnesses?
That's a really good question, because a lot of us expected her to have a mini trial, which would be an airing of the evidence. Mike Pence would get on the stand, and it would be really compelling. And it would happen before the election, and the public would learn about Trump's involvement before, during, and after January 6th, even though there would be no trial until after the election. But according to recent reports, Jack Smith and his team are not going to push forward for a mini trial. Ultimately, it's up to Judge Chutkan to decide. Judge Chutkan could decide that she can make these decisions based on the paperwork, the pleadings. You don't need verbal testimony, but it will be up to the judge to decide. And then the question is, when would it happen? Would it happen before the election or after? These are the questions, I think, that you can do a mini trial before the election. Ultimately, the decision on whether to have a mini trial should be based on the evidence and the law and should have nothing to do with politics. You shouldn't be concerned that there's an election around the corner, and you shouldn't be concerned that people are going to interpret it as being political, because whether you do or you don't, you're going to be accused of weaponizing the Department of Justice, even though you're not. So you just follow the evidence and the law and tune out the noise.
But there is so much noise, Dave. Let's turn now to Florida. The special counsel's asking the 11th Circuit to reinstate the classified documents case, saying that Trump appointee Judge Eileen Cannon's decision to throw the case out runs counter to precedent, rulings by judges across the country, history, and the long-standing practices of the Justice Department. Remind us about Cannon's decision dismissing the case.
Judge Cannon made such a bizarre decision that it went against all precedent, and I think will almost certainly be overruled by the 11th Circuit. Cannon's best chance to keep this on the books would be if the Supreme Court decides to weigh in and then does something radical like they did in the immunity case. Clarence Thomas has already issued a concurring opinion that provided a roadmap for Judge Cannon to rule the way she did, but no other justice signed on to his concurring opinion, so I suspect the Supreme Court would not even go along with her approach. I mean, I'm old enough to remember a guy named Robert Mueller and Robert Hur and David Weiss. These are all special counsels in recent years, and there was no issue whether they could remain because of the constitutionality of their appointment. Judge Cannon applied a different set of rules to Jack Smith, and she'll be overruled for it. Then the big question is, will the 11th Circuit remove her from the case? I know Jack Smith would want that. He did not ask for it specifically, but the 11th Circuit has the power to do it on its own. Don't know if they're going to do it yet, but maybe that day will come.
What I think is one of the best lines from Smith's brief is, quote, "From before the creation of the Department of Justice until the modern day, attorneys general have repeatedly appointed special and independent counsels to handle federal investigations, including the prosecution of Jefferson Davis, alleged corruption in federal agencies, including the Department of Justice itself, Watergate, and beyond." His argument covers the legal landscape.
The precedent is that special counsels are legit, they're legal under the law, they're an inferior officer, and an attorney general can appoint them, whether it was Archibald Cox or Robert Mueller. And, over the years there have been different statutes in place, and the statutes may have not been reenacted or, repealed, but special counsels remain. And there's never been any court that has looked at this issue, because courts have. There's never been a court that has said, yeah, it's an unconstitutional appointment. You have to be confirmed by the Senate. It's never happened. It didn't happen with Clinton and Kenneth Starr. It didn't happen with Nixon and Archibald Cox. In fact, in the Nixon case, the Supreme Court did weigh in on this. And in dicta, meaning in just extra language in the opinion, that they did say that the special counsel was legit. The way that he was appointed was okay. And so this goes against precedent for years, including Supreme Court precedent. And so that's why I'm very confident that Judge Cannon is going to be overturned.
Of course, it's unlikely that we'll even get through the 11th Circuit's process before the election. So whether or not these cases go forward depends on who's elected president. Thanks so much, Dave. That's Palm Beach County State Attorney Dave Arenberg. Coming up next on the Bloomberg Law Show, Republican states sue over a Biden program that would give undocumented immigrants married to U.S. citizens a pathway to citizenship. I'm June Grasso, and you're listening to Bloomberg. Texas and 15 other Republican-led states are suing to end a federal program that could give 500,000 undocumented immigrants married to U.S. citizens a pathway to citizenship. Getting legal status after marrying a U.S. citizen is actually a long and tricky process for people who entered the country illegally. They have to first return to their home country before they can legally reside in the U.S., risking years-long or even permanent separation from their families. President Joe Biden had announced the program called Keeping Families Together in June.
For those wives or husbands and their children who have lived in America for a decade or more but are undocumented, this action will allow them to file a paperwork for legal status in the United States. Allow them to work while they remain with their families in the United States.
The states suing to stop the program say that the administration bypassed Congress to create a pathway to citizenship for, quote, blatant political purposes. On Monday, a Texas federal judge put a 14-day hold on the program, although the government can continue accepting applications. Joining me is Leon Fresco, a partner at Holland & Knight and the head of the Justice Department's Office of Immigration Litigation in the Obama administration. Leon, tell us about the program.
It's called the Keeping Families Together program, or it's also known as the PIP, the Parole in Place program. It's a program that the Biden administration put in at the same time that it put in its executive order closing the border to balance that out by saying that in addition to that provision, there would be a provision that would be more compassionate that would say that people who are married to United States citizens but who cannot obtain legal status because they crossed the border of the United States unlawfully, those individuals will now be able to get legal status because the thing that was banning them, which was that their admission was not done legally, will be cured by this parole in place, which will basically say, we will now admit you, but we won't make you actually come to the border and re-enter legally. We'll just give you a parole, which is sort of a permission slip that says, as of this moment, you entered the United States legally, so now you can go ahead and petition for a green card or lawful permanent residence, as it is known, because of your marriage to a U.S. citizen.
So Texas and 16 Republican-led states are suing to end the program. What's their main legal attack?
Well, they have a lot of different theories about why this is not a legal program. But basically, it comes down to that they say that the parole program that the Biden administration has put in is suffering from two main legal defects. The first is that the very concept of parole in place, although it's been used in the past, and it was used mostly for the undocumented spouses of people in the military, So nobody cared because people didn't like the idea that a person in the military could have their spouse deported. So people generally thought that was fine and didn't sue at the time. But now they're sort of saying, look, we should revisit this concept of can you actually be given a parole if you're already inside the United States? So that's their first argument, is that concept in and of itself is illegal. That what a parole is it's a permission for someone who's at the border, who's outside of the country, who's trying to enter. It's a permission to allow them to enter, but it's not a document that you can get once you're inside the United States. So that's their first argument. Their second argument is that in 1996, Congress dramatically limited the parole authority to a case-by-case basis and upon an urgent humanitarian circumstance. And they're saying that neither of those two things applies here because this isn't a case-by-case basis. This is a programmatic change where even though the administration is saying, look, there's discretion to deny this on a case-by-case basis and all decisions shall be made on a case-by-case basis, they're saying there's sort of this wink-wink understanding if you meet the criteria for the program, you are going to get it. And so they say that violates the case-by-case requirement. And they're saying that, look, even if this was case-by-case, you can only grant parole for urgent humanitarian reasons or for a significant public benefit. That's the two words that are in the statute. One is urgent humanitarian reason. Second is significant public benefit. And they're saying that neither actually exists here because all this is an end run around what Congress wanted. Congress didn't want people who cross the border without authorization to be able to gain legal status in any way. They wanted them to have to leave and have to redo it from the outside. And so they're saying it can never be an urgent humanitarian reason or a significant public benefit to have a parole program whose goal is to circumvent the Congress's statute.
The Republicans who are attacking it say it's essentially a form of amnesty for people who broke the law. I mean, Biden is giving special privileges to people because they happen to be married to U.S. citizens, whereas other people who are here who crossed illegally as well and who've been here for the same amount of time and who haven't violated the laws, et cetera, aren't given this. So it does seem a little bit unfair.
Whatever word you want to use, amnesty or some other word, it is correct to say that people who are currently in an unlawful status will, if this program survives these court cases, be allowed to enter not only into just a lawful status, but ultimately to lawful permanent residency, and ultimately, even after that, potentially U.S. citizenship, if this program is allowed to continue, so long as they were married to U.S. citizens. And it is true that all of this is sort of being made up on the fly in the sense that this requirement that you had to have been in the country for 10 years. None of this is based on anything. It's just the way they wanted to define the program, which is that you have to have been here for 10 years and you have to be married to a U.S. citizen. And you're correct. There's other things you could be that could be more compelling or less compelling, but this is the concept that they chose. And one would say, well, why did they choose this? Well, one is because there's an actual U.S. citizen who sort of has skin in the game here, and that there would be harm to that U.S. citizen if they lose their spouse due to deportation. But secondly, there is this concept that was already in place in its entirety, but the only difference was the only people who could take advantage of it were spouses of people in the military. So now it will be spouses of all U.S. citizens.
And the Republicans also say that, this is close to the election. It's blatant. The Biden administration is playing politics here. I mean, has this idea ever come up before?
Sure. When the military parole program was announced, this was the fear of a lot of Republicans. They said one day somebody's going to try to expand this to all U.S. citizen spouses, and they will say, because we didn't object to it at the time when we did it for the military, that we lost our right to object to this. And lo and behold, some of those people who did criticize the program at the time have been proven right, that ended up happening, that this program did get expanded. But it is also true that no one filed a lawsuit or objected to the military parole program at the time, other than some of the people who do this professionally for a living who don't want any programs of any kind done. They did say this would happen, and so now it has happened. So from the extent of has this been considered, the idea was, yes, it was considered from the day that the military program was announced over a decade ago, that would be the potential outcome of this, as they would try to do all spouses at some point. But was this done as an election item? Well, certainly It was done very close to the election. It was done at the same time that the border was closed to appease people who were criticizing that the border was closed. And so there's not an immunity to those criticisms because one could point to those facts and say this was done for political reasons. In any case, the question is what happens now, and the administration is taking these applications, and I think both immigration lawyers and the clients going through this need to be very careful and need to decide, is this something that I want to do, where if this gets enjoined or if the administration changes, and now I've put my name forward and I've exposed myself as someone who's here illegally, and I've given my address and I've given all my biographical information, I can be found immediately. Is that something people think is wise to do? So I don't know how many people you're going to see applying for this. So to that extent, it is potentially a useful political move, but a political move nonetheless.
They estimate that about 500,000 people could be eligible. Factor that in. So what do you think? How strong are the Republican states' arguments against this program?
The arguments about the way you read the statute are now going to be viewed along the lines of no deference to the administration any longer, as we now know. And so the question is, does the statute, when you have a plain reading of it, permit this type of parole in place? And that's ultimately going to come down to one judge in Texas. Well, first there will be the standing question, and the standing question will be very interesting because the most likely way that the states will lose here is in the standing question, which they've lost recently in other lawsuits, because the argument would be, why would it be a problem to take people who are here unlawfully and make them legal? What harm does this do to the state? And the state is saying, well, 5 years from now, we may need to give benefits to these people when they're eligible for benefits. But interestingly, there's a thing in the law called an affidavit of support, which says that if you're sponsoring someone for a marriage-based green card, you actually have to prevent them from getting benefits, meaning you have to pay for whatever it is they need under the law. So it actually will be very interesting to see on standing if the state loses. That's the most likely way the states will lose. But if they can survive the standing issue, then the question is going to be, will a judge, first in Texas, then the Fifth Circuit, then the Supreme Court, decide by looking at this statute, just the plain language without any deference, two things. Is parole something you can actually do inside the United States? It'll be hard to make that argument. I don't know a very clear statutory reference that says you can grant parole already inside the United States, as opposed to that's something that's happening at the border. Now, that problem theoretically can be fixed by making everyone in this program just check in at the border and come back. So that would sort of be a Pyrrhic victory for the state if they ended up winning that, but fair enough. But then the second one that I think they more want to win on is that there isn't a significant public benefit or an urgent humanitarian reason for doing this. And I think that's where the rubber is going to meet the road, and that's literally just going to be the opinion of the judges, because if there's no deference, then the judges have to decide, is this an urgent humanitarian reason or a significant public benefit, or isn't it? And I think that's going to be a very interesting question, which will just be in the eye of the beholder.
And the beholder will be a Texas judge and then the very conservative Fifth Circuit. Now, Judge Campbell Barker, who issued the 14-day stay, said he decided on it after undertaking a first-blush review of the merits of the state's arguments. Quote, the claims are substantial and warrant closer consideration than the court has been able to afford to date. So we'll see what the judge does after the 14 days. Thanks so much, Leon. That's Leon Fresco of Holland & Knight. Coming up next on the Bloomberg Law Show, he was a famous, rich L.A. lawyer, made even more famous by the movie Erin Brockovich and as the husband of one of the Real Housewives of Beverly Hills. But Tom Girardi, now 85, broke and suffering from dementia, is facing prison time after being convicted of stealing millions from his clients. That's next. I'm June Grasso, and you're listening to Bloomberg.
Mr. Girardi was no champion of justice. In fact, he was a perpetrator of injustice, victimizing his own clients when they were most vulnerable and most in need.
Tom Girardi has gone from famous legal heavyweight to disgraced, disbarred lawyer to convicted felon. Girardi was catapulted into the national limelight after the 2000 Oscar-winning movie Erin Brockovich showcased his role in getting a more than $300 million settlement from PG&E for poisoning a California town's drinking water.
In the interest of putting this whole thing to rest, PG&E is willing to offer the Jensens $250,000 for their home.
$250,000?
In terms of land value out in Hinckley, Mr. Masery, we feel that's a more than fair price.
How about in terms of medical expenses? $250,000 isn't going to come close to what this family is going to have to spend on doctors.
He was hailed as a pioneer of toxic tort litigation, known for getting massive settlements for his clients.
This season on The Real Housewives of Beverly Hills.
And his fame was enhanced as the husband bankrolling the extravagant lifestyle of one of the Real Housewives of Beverly Hills, his wife, Erica Girardi.
I'm an enigma wrapped in a riddle and cash.
But U.S. Attorney Martina Estrada says Girardi funded that extravagance by embezzling tens of millions of dollars from his clients in a 10-year Ponzi scheme.
Yet Mr. Girardi chose to take advantage of those very same clients, those vulnerable people, the ones who'd gone through traumatic incidents, in order to enrich himself.
A Los Angeles jury agreed and convicted Girardi of 4 counts of wire fraud. So now at age 85 and suffering from dementia, the once high-powered lawyer is facing jail time. Joining me is Bloomberg law correspondent Maya Spoto, who covered the trial. Maya, how did the prosecution present its case against Girardi?
So the prosecution's case started rooted in the testimonies of these clients whose missing funds made up the backbone of the charges against Girardi. And so the first witness we heard from was Joseph Rigomez. His home exploded and his body was covered in burns, and his girlfriend died in the explosion. And so we saw him limp up to the witness stand and explain how Girardi used these excuses, such as a fake 6.5% interest accruing savings account and this fake excuse that he needed approval from a judge to justify stalling these payments to Rigomez. And we heard these excuses get echoed throughout the remaining clients who testified. These excuses became ridiculous. There was one excuse that Girardi used where he said he was having the funds held up because he was working on a tax issue, which would tax women more than men on certain personal injury settlements, and he needed to work that out with the IRS. And even a lawyer at the firm who was freshly out of law school and had just passed the bar spotted that excuse and said that makes no sense. And so we started the case hearing about these excuses and the pain that they caused for clients. And then the prosecutors presented their detailed path where they followed the money. And we heard from the federal government on what these client trust bank accounts really looked like and where the funds were going. So that's how we got into more of the lavish lifestyle part of the case.
Fans of The Real Housewives know about that extravagant lifestyle. How much did the jury learn about it?
Jurors saw so much money being used to purchase different categories of luxury items, such as 2 private jets. Girardi purchased expensive jewelry. We saw a check written directly out of one of the client trust accounts for $750,000 to pay for diamond earrings for his now estranged wife, who is Erica Jane. We also saw how funds were taken from Girardi Keith to pay for Girardi's memberships in country clubs. One of the lawyers at the firm charged property taxes to his Girardi Keith American Express card. And we also heard details about the lavish parties that were hosted on the company's dime, which had 6-figure entertainment budgets. There was a Super Bowl party where lawyers were given as goodie bags their own personal jerseys. And all of these parties were being hosted while some clients who were in immense pain still were not receiving all of the settlement funds that they were due.
The testimony of the client victims was very emotional at times. Tell us about the most compelling testimony.
So the one that I found most compelling, and also the first client witness that one of the jurors named when he spoke to reporters after the decision, was Erica Saldana's. She showed up to court actually with COVID and had to testify remotely, but she was sobbing for much of her testimony, had to push up her glasses to wipe away her tears because she was crying so hard. Her very young son was immobilized after a drunk driver crashed into Saldana's car, and she turned to Girardi Keith for representation, but she never received from the firm the entire amount of her settlement, which she needed to purchase an accessible home for her son. And so Saldana spoke of how she spent the last year of her son's life chasing down Girardi to ask for the money she needed. And at one point, Girardi even called her while she was in the hospital with her son and accused her of not being sympathetic to Girardi's own health issues. He was having, he said, eye cancer surgery. And she said, how can you accuse me of not being sympathetic to health issues? My son is dying.
And the jury heard Girardi's own voice in voicemail messages giving his clients these excuses.
Yes, one of the common refrains that he would say to clients was, don't be bad to me, don't be mad at me, I'm a good guy. He would tell clients, including Joe Rigomez, that he loved their family. This was one of the most important cases to him. He would, even into the late years of the firm, send these detailed messages where he got the facts of the case right. He knew who he was talking to, and he was just saying, please, don't be mad at me. The payments are coming later. Here are the reasons why they're being held up.
So the prosecutors say it was a Ponzi scheme. How did they show that?
They basically showed how, they said, Client 3's settlement funds were used to pay off Client 2's settlement funds, which were used to pay off Client 1's settlement funds. And they had an IRS agent present an analysis of bank records from the firm's client trust accounts, which showed how the settlements from later in the 2010s were used to pay a client whose settlement was made in 2013. And the firm's client trust accounts are subject to these rules that are very strict, where you can't commingle funds and you can't have a negative balance in the account. Otherwise, it would alert the state bar. But these transfers happened anyway.
The defense tried to shift the blame to Christopher Camone, the former chief financial officer of the law firm, saying he was the one responsible for the loss of client funds, not Girardi. He's going to be tried separately in January. Why didn't that defense work?
It wasn't successful because the prosecutors emphasized in closings that they have substantial evidence against Camone and that he is a co-defendant in the case and he will see his day in court. The defense spent a lot of time going through records of how Camone used Girardi Keith's funds to pay essentially shell companies that were either companies where Camone had a leadership role or he was closely affiliated with members of these companies. And they also described how he paid $20,000 a month from the firm to his then fiancée. She testified. And he purchased lavish trips for the two of them. And so the picture that the defense was trying to paint was that Chris Camone was basically taking advantage of Girardi's declining mental state and taking these funds out from under his nose. But the jury didn't ultimately buy that.
Girardi is suffering from dementia and is currently living in the memory ward of a nursing home. So I was very surprised that he took the stand. Was his testimony coherent?
Everyone in the audience was shocked. It was a surprise move. He got up on the stand, and at first it seemed like this was just something that had been programmed into him from years of being this formidable trial lawyer. He had all the instincts. He smiled at the jury. He addressed them when he spoke. He made jokes. He tried to banter with the prosecutor, but it became clear as he was speaking that he was getting some pretty important facts wrong. He said that he thought the Girardi Keith law firm was still running when it closed down and went into bankruptcy several years ago. And he also said he didn't know his own lawyer's name. And the exact quote, this was the last question that his defender asked him. Sam Cross said, "Tom, what's my name?" And Girardi said, "I have no idea. Bad, mean, terrible. It's one of those."
Do you think his cognitive decline, his dementia, made him at all sympathetic?
It was hard to feel sympathy after all of the clients explained exactly how this theft had ruined their lives. I think that the defenders were leaning hard into the appeal to jurors who had family members with dementia, which my grandmother has dementia, so I was thinking of her. But he talked about how his mother, who was a lawyer too, had dementia for a couple of years and eventually had to hang up the hat. And he was very emotional as he was saying this during closing arguments. But ultimately, I don't think that appeal worked.
Apparently not with the jury, at least. Did the prosecution acknowledge that Girardi has cognitive issues, and how did they deal with it?
Yes, they said now it's pretty clear that he has cognitive issues, but it's 2024 now, and he didn't conduct the scheme in 2024. It was from 2010 to 2020.
It was a 12-day trial, and the jury came back with guilty verdicts on all counts after just 4 hours of deliberations. Did Girardi react when the verdict was read?
He did not react as it was read in any significant way. But after he was standing up from the table and walking out, he had this kind of smile on his face that we had seen throughout the trial, which I describe as kind of waxen. And he walked out pretty steadily. One of the reporters asked him if he had comment on the verdict, and he chuckled and he said, no.
And Maya, you spoke to one of the jurors who said it wasn't a hard decision.
He said that the facts were all there. We asked him if anyone on the jury needed to be convinced, and he said no. He's not perhaps representative of the entire group of jurors, but he made it sound like there was very little resistance inside the room.
Girardi faces decades in prison when he's sentenced on December 6th, and the U.S. attorney said the fact that he's older doesn't mean they won't seek prison time. So we'll have to see what prosecutors ask for. Thanks so much for coming on the show, Maya. That's Bloomberg Law correspondent Maya Spoto. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.